Someone make it make sense.
Probably a couple.
What is up, party squirrels? I'm excited to be back with some Kohberger after being in a Karen Reed frenzy, a Karen Reed nightmare. How would y'all describe it? Of course, we have that hearing happening tomorrow. So the plan for the hearing is they're going to have a sealed portion dealing with the alternative perpetrator evidence, and then an unsealed portion where they're going to hear or Judge Hippler is going to hear argument on the defendant's motion to continue. So because we've already covered previously the defendant's motion to continue, we are now going to take a look at the state's opposition to the defendant's motion to continue so we can be all ready for the hearing. And so this was filed on what day? Someday, June the 5th. So we're going to take a look and see what the prosecution has to say. Of course, this motion to continue comes in the wake of all of the recent develops regarding the leaks, potential law enforcement or prosecution leaks to media outlets right before trial. And when the defense made their motion to continue, they had a number of different grounds, but far and away, in my opinion, their strongest ground was the fact that there's been all these leaks. And, I think they have a really strong argument here. And it also, the other thing is it's clear that Judge Hippler is not playing around with this, and he thinks this is a very serious issue, which it is. And the last hearing they had, he definitely seemed open-minded, if you will, if not almost suggesting that there might be some serious actions that need to be taken due to these leaks. So we'll see what happens, but let me see what you guys are saying in the chat here. Welcome, Angel. Welcome, Kane. Welcome, Twiz. Happy to see you guys again. Some of you guys were just here a little bit earlier for Karen Reed, but if you weren't, welcome on in, my squirrel friends, squirrels of the world. Okay. We got the rat daddy in the house. All right, so let's just take a look here and see what the state has to say. Oh my God, I'm already offended, y'all. Introduction. It is time to try this case. Well, I would say that's more like argument and not introduction. The introduction should be the facts of the case, which now they're going to get into, but this first sentence right here is definitely argument and really should be reserved for like the very end of their argument, kind of, if they're going to say it at all. Anyway, we don't need all the facts of the case. We know all of this in terms of the initial background, the scheduling order, deadlines. Okay. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, defendant seeks a trial continuance of unspecified length. Well, having said that, this is me interjecting. I don't know that it was unspecified because there was discussion about the cooling off period, which I think Judge actually had referenced previously. We covered this on, I guess it would have been the most recent Kohberger live stream, although that wasn't that recent. But whenever we covered the defendant's motion to continue, we talked about this, the cooling off period, and that the studies show that it actually works. And my recollection is it was 6 months. So anyway, the state is saying unspecified length. Oh, also, that's what she said. He bases his request on his claim that his mitigation investigation is incomplete. That's one of their grounds. They had I think 5, if I recall, separate grounds, and it was clear that the first 4, they already had these ready to go, and it was kind of more like a boilerplate motion. But then they had added on the last one dealing with the potential leaks which, of course, in my opinion, is their strongest ground. And notice that state's not referencing that yet. They're talking about the mitigation investigation. While state is unable to see whether defendant's ex parte filing to the court contains specifics, his motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how the investigation will actually produce them. Overall, the record before the court shows that the defendant's investigation has already plowed the necessary ground. While defendant is fully entitled to due process, this court should exercise its broad discretion to deny the defendant's 11th hour motion. Well, it's really not the 11th hour. 11th hour would be like end of July. First, defendant cannot show good cause or prejudice. Even under the heightened, non-binding ABA standards he seeks to impose on the court, his counsel's resources and investigation to date have been adequate. Even setting aside, the defense team still has more time to prepare its mitigation case. Moreover, Idaho's constitution also grants the victims the right to a timely disposition of this case. The court should give these victims' rights substantial weight in considering the motion. Okay, yes, but as we all know, the defendant's rights come before anyone else's when it comes to a criminal trial. Finally, the publicity surrounding this trial is a challenge. Defendant has not shown and cannot show that continuing this trial will make things any easier. Well, I disagree. I think they have talked about that, and I would expect they intend to show that at the hearing tomorrow. It is just as likely that delay will make it harder to seat a jury. That's factually not true. For all these reasons, the court should deny the defendant's motion. All right, again, procedural and factual background. We don't need all of this. Change of venue. And again, that cooling off period was discussed, if I recall, by Judge in the order granting the change of venue as something he considered. Okay. More recently, at the pretrial motions, hearing on April 9th, the court advised defendant's counsel to ask for more resources if the defense team needed assistance reviewing discovery. The state does not know if this occurred. That was actually, by the way, April 9th. So that must have been the most recent hearing until tomorrow. Is that correct? Or was there one after? No, that's the most recent one. Interesting. Wow, that was a long time ago. Throughout the case, defendant has been able to comply with the deadlines in the scheduling order. Pertinent to the instant motion the defendant has, and now they're basically noting all of the different deadlines that the defendant has complied with. Okay. Defendant also opposed the state's motion for examination of defendant pursuant to the Idaho Code and for an extension of time to complete rebuttal penalty phase expert disclosures. At that time, defendant did not preview for the state or the court that he would seek a trial continuance, and the court denied the state's request for personality testing by its expert in part because the pending trial date conflicted with the time that would be necessary to explore that issue. I think the defense addressed that in their motion, and again, for more on that, you can check back to that live stream. And of course, there's a playlist for all of the cases that I'm covering and have covered, including a playlist for Idaho v. Kohberger. And all of the videos are listed in chronological order. I think at the top, it's like newest first, but you can all sort those however you want as well for anyone who wants to start at the beginning if you are new to this case. Legal background. Trial judges necessarily require a great deal of latitude in scheduling trials. Accordingly, the decision to grant or deny a motion for continuance rests within the sound discretion of the trial court. So they're appealing to Judge Hippler here, although again, he doesn't seem to be very happy with the state in the wake of all these leaks, potentially. When reviewing a trial court's decision for an abuse of discretion, Idaho appellate courts analyze whether the court, and we've read, these are the same 4 prongs. We've read these a bazillion times. I'm not going to repeat those. The United States Supreme Court has held that the denial of a motion for continuance is grounds for relief only where the trial court's action, quote, is so arbitrary as to violate due process, end quote. Similarly, let me just pause for a moment. So in other words, granting a motion for continuance would be necessary when the defendant's due process rights would be violated. So, again, I think this actually bodes really well for the defense, right? Again, my opinion, most importantly, because of this entirely messed up situation that just unfolded recently here with these leaks, and also the pending investigation into the leaks. Similarly, under Idaho law, unless an appellant shows that his or her substantial rights have been prejudiced by reason of a denial of his or her motion for continuance, appellate courts can only conclude that there was no abuse of discretion. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice as to support a motion for continuance. Notably, they've not yet addressed anything having to do with these leaks. You'll see here, right? They're not mentioning that yet. We'll see what happens. At a minimum, some showing of actual prejudice must be made. Footnote 2. So the Ninth Circuit precedent holds that a trial court must consider the defendant's diligence prior to the requested continuance. Okay, I think the court here will find that the defendant's counsel has been diligent. 2, whether the continuance would have served a useful purpose. Here, I think the court could easily find it would serve a useful purpose. 3, the possible inconvenience to the prosecution and or court. Again, here, I think the court could very easily find that any of those inconveniences are outweighed by the prejudice to the defendant, again, due to these recent leaks. And 4, whether the defendant was prejudiced by the denial of the requested continuance. Again, I think the court could easily find he would be prejudiced if the continuance was denied. In exercising their discretion, trial courts are also guided by the Victims' Rights Amendment, timely disposition again with that. Okay, now here's their argument. Shout out to Too Fast. Happy to see you. As you guys know, it's harder to read the chat while I'm reading the document, so I'm just going to take a look and see. What chat is volatile? Oh, some channel I don't know of. Okay, not here, obviously. We have a very nice, lovely, scrolly chat. So yeah, welcome Too Fast. All right. Defendant couches his motion in terms of his constitutional rights to due process, to effective assistance of counsel, to an individualized sentencing determination, and to fair trial in light of intense media coverage. They're not even acknowledging the leaks. Interesting. But he has not demonstrated that these rights, which must be evaluated alongside the victim's rights and the overall administration of justice, will be violated if this case proceeds as currently scheduled. The court should exercise its discretion to deny the defendant's motion because he has not shown good cause for continuance or that he'll be prejudiced. Substantively, he ignores Idaho Supreme Court death penalty precedent holding that counsel is, quote, not required to investigate a defendant's entire life before he can be tried or sentenced. Interestingly, the defense cited case law that said literally the opposite. And it wasn't just case law. They also cited like the ADA rules and other sets of rules that are specific to death penalty, court-appointed death penalty counsel. They cited a whole bunch of stuff. I mean, that was a long section of all of the things that they cited to support their duties that they are required to do. And they many times reiterated that they have to investigate the entire life. They said that. He neither specifies additional areas for investigation nor explains what concrete investigatory steps will bear new fruit at either the guilt phase or the penalty phase. Well, how will you know if the steps will bear new fruit if you can't take them? You have to take them to find out if there's new fruit, I would say. As such, defendant's motion amounts to a request for a perpetual continuance so that his counsel can go down every rabbit hole, rude, until the defendant, rather than the court, deems himself ready for trial. The law requires no such thing. I mean, I will just say, I understand when sometimes there's motions that are filed that might seem a bit frivolous or hyperbolic, and I don't fault defense counsel for that when it's a death penalty. Well, in a death penalty case, as you guys know, they have to file for everything. I just want to say that I did not interpret this motion to be like hyperbolic or frivolous at all. Potentially, had there not been any of those leaks or whatever with the documentary and the books and all that shit that's happening like right before trial, if you took all that out of the equation, then maybe I would still not hold it against them, but it would seem like a last minute trying to continue the trial, right? But that motion came in the wake of that hearing where Judge Hippler scolded the prosecution and all that stuff. It's just very different. And again, I feel like it has a lot more oomph behind it for that reason. The court should deny the motion because defendant's team has had the opportunity to prepare and has adequately addressed the issues he claims need more attention. Defendant's motion is untimely given the procedural posture of this case. Are they just, I mean, they can't just ignore that whole thing completely though, right? Like that would be insane. Are they going to try to do that? They're just talking about discovery deadlines. Instead, defendant retained over a dozen guilt phase experts, 6 penalty phase experts, a mitigation specialist, without stating he would be moving for a continuance. Again, I could understand complaining about this were it not for the most important part of the defense's motion, which the state is ignoring. While defendant relies on the death is different mantra and argues that extraordinary measures must be taken to protect his rights, he cites no authority for the proposition that reasonable scheduling orders should not be enforced in death penalty cases. Indeed, defendant recently argued that the state improperly delayed in seeking an extension of time for its rebuttal phase expert disclosures. Welcome, Miss Q. Happy to see you again. Defendant's purported need to conduct additional investigation is unsupported and does not establish prejudice warranting a continuance. Wow, sounds like this just comes across as kind of, it's not to try to compare anything to Bryan or Karen Reed because, pretending that doesn't exist, that case doesn't exist for a brief period of time to read this document. However, it's like when the defense makes a really strong argument and states and lays out that argument, and then the government comes to argue in opposition and literally ignores the argument, the strong argument that was made, and just completely doesn't address it, and instead just says other things. Kind of reminds me of that a little bit here. He's not demonstrated that he's being deprived of anything that he seeks. I mean, okay. Defendant's legal resources have been more than adequate. Defendant has 3 trial attorneys. No one's disputing that. Santa or Jennings or whoever wrote this. This record reflects that this defense team has been working hard for the defendant and, as explained below, has met the professional standards for the defense of a death penalty case. Again, this would hold more water for me if not for their strongest argument, which the state is ignoring. Their strongest argument, as in the defense's strongest argument from their motion. Yet defendant still claims that this court is cutting off his review of discovery. This is unfounded. Oh my God. Defendant's attorneys have had sufficient time to review discovery and have not established any discovery violations by the state. They have been able to identify The court recently admonished defendant's counsel to seek additional resources from the resources judge if they needed more assistance, notably leaving out the admonishment given to the state for the leaks. Defendant has not claimed that he sought more resources and was denied. I mean, okay, I'm sure we'll learn more about that tomorrow. Defendant's expert witness resources have been more than adequate. This is quite redundant, isn't it, here? Collectively, these experts took a deep dive into the defendant's entire life, including interviewing his family, The extensive investigations by these experts contradict the defendant's claim that he needs more time to complete a social history investigation. In the cases he cites, counsel was ineffective for failing to explore mental health conditions or for failing to provide mental health experts with sufficient background information. In contrast, here, defendant's mental health experts have had access to a significant amount of people and materials and have created fulsome. Oh my God, is he watching, whoever wrote this, are they watching Karen Reed? I mean, literally, I've never heard the word fulsome. I mean, I've probably heard it in my life. I've never heard it used like in just people talking, literally until the Karen Reed trial. And it came from Mr. Alessi, and then everyone else sort of adopted it. And now you hear it from everybody. But this is the first time I've seen it from anybody in this case. So that's interesting, isn't it? I wonder if we'll see full-throated as well, or parlance. Fulsome histories through their own investigation. Defendants claim that his team needs to follow up on red flags is also unsubstantiated. In their reports, neither his psychologist nor his forensic psychiatrist indicated they could not render opinions because of unexplored areas. In fact, the forensic psychiatrist concluded the defendant showed no signs of other serious psychotic disorders, and at a recent hearing, defendant represented that he would not seek to introduce evidence on this unexplored topic. Well, isn't that because it has to be saved for the mitigation phase? Anyway, tellingly, defendant did not seek an extension of the penalty phase expert disclosure deadline. Defendants claim that more expert testimony is needed is speculative and does not identify what new information would be uncovered by further investigation. Again, chicken and egg, right? Don't you need to? Anyway, this is fatal to the defendant's motion. All right. Defendant's counsel's investigation into his life story has been more than adequate. And far be it, this is me interjecting, far be it for the prosecution, though, to determine what is adequate for the defense here, right? And his reliance on the ABA guidelines is misplaced. That's interesting. How so? There is no authority to support the defendant's desire for more time to conduct a scorch the earth life history investigation. Courts recognize that all cases, including death penalty cases, are constrained by limited time and resources. Again, this is case law that is directly contrary to what the defense cited. So this will be interesting to see what happens tomorrow as it pertains to arguing these other issues. By other issues, I mean besides the leaks. Faced with this authority, defendant turns to straw man arguments, and non-binding guidelines to conjecture up alleged prejudice. First, he cites cases where death penalty sentences were overturned because lower courts failed to consider mitigation evidence. But there's no danger of that here. Starting the trial instead of allowing defendant to pursue a mitigation investigation with no end in sight does not amount to denying him the right to present a constitutionally adequate mitigation case. In any event, the current issue before the court is a request for continuance, not the admissibility of mitigation evidence or the performance of counsel. The court's decision remains a matter of discretion. Second, the defendant relies on the ABA guidelines for the appointment and performance of defense counsel in death penalty proceedings to list all the things that his counsel needs to accomplish. This exercise is meritless as a matter of law and fact. As to the law, the Idaho Supreme Court has declined the invitation to adopt these guidelines. So the Idaho Supreme Court is given the ABA, as in the American Bar Association, the middle finger, it looks like. Interesting. For its part, I was literally just going to say, well, what does the Supreme Court think about this? For its part, the United States Supreme Court has ruled that the ABA guidelines are just that, only guides. Wow, though, but do you really want to be like, we're not following those? That's wild to me. I mean, I didn't even know that you could. I thought that it was like, you had to. That's wild. As a factual matter, even if the court looks to the ABA guidelines, the record reveals that defense counsel has complied with them. Well, then, okay, fine. They've got a footnote here. The state does not address point by point the list of tasks cited from the declaration of Elizabeth Varkesian. Defendant's reliance on this mitigation specialist from an unrelated case reflects the unending nature of the analysis the defendant is seeking to impose on the court. Areas of inquiry identified by a non-judge in a far-flung case should carry no weight. If they did, defendant could delay this trial indefinitely by continuously filing previously unidentified topics that someone somewhere says his counsel should investigate. Wow. The results show that an appellate court will be exceedingly hard-pressed to rely on the ABA guidelines or any other basis to find the defendant has suffered prejudice if the trial proceeds as scheduled. Defendant's ex parte filing should not cause the court to grant his motion. Okay, so the ex parte filing purports to outline what new evidence he might seek and what strategies or tactics he might use to obtain such evidence. So this is one of the things that the state was just complaining about. They're like, the defendant has not shown what they hope to gain from an additional investigation or how they would go about doing it. But now the state is literally saying, oh, well, they actually did that, but they did it ex parte. So okay. Initially, the court expressed skepticism that the defendant's motion was properly filed ex parte and ordered the defendant to provide a redacted copy of this filing to the state for it to address in this response. Defendant then objected to that order, and the state now understands that the court has decided not to require disclosure of the ex parte filing. So Judge Hippler sided with the defense. It's like, while the state does not concede that the defendant has valid grounds for his objection, it will not address the objection given the court's decision. The state, however, does request that if the court has identified a basis in the ex parte filing to grant the defendant's motion, that the court allow the state to respond to that particular issue. Interesting. So the defense was going to turn over a redacted version of the ex parte filing to the state, but then they changed course, and Judge Hippler said they didn't have to do that for certain reasons, right? Probably because it would be prejudicial to the defense, right? That there's reasons why this is, trial strategy and whatnot. So, a bit rude then for the state to comment on the defense making a lack of a showing of how they intend to further investigate and what they expect to gain when the state was denied by the judge to have any access to that information. Okay. The Idaho Constitution's Victims' Rights Amendment is another basis. I'm not even going to read this because we all know a defendant's rights are more important, no offense to victims. Despite intense publicity, okay, let's see if they finally address the really big issue here, in my opinion. The court should exercise its discretion to deny the defendant's motion and proceed to trial using its carefully planned jury selection process. Are they going to discuss this? There is no doubt that the publicity surrounding this case, including but not limited to a recent Dateline show containing non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks. Okay, finally. And to assist in determining which person or persons provided non-public information to Dateline. However, defendant's reliance on the Dateline episode to support his motion is misplaced for several reasons. Oh, do tell. First, the question of whether defendant can receive a fair trial is not answered by the amount of and the nature of pretrial publicity. How is that the case? Rather, it depends on whether a fair and impartial jury can be seated. Okay, yeah, that's true. Miss Q is asking, when was Folsom in reference to? Let's see. Folsom histories in terms of the defendant's mental health experts. They've created Folsom histories. That's when Folsom was there. Okay. Okay. The state reaffirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks and to assist in determining which person or persons provided non-public information to Dateline. However, defendant's reliance on the Dateline episode to support his motion is misplaced for several reasons. All right, I already read this. We were here. As the U.S. Supreme Court has said, to hold that the mere existence of a preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. And we hear this in a lot of these high-profile cases, right? It's sort of like, okay, maybe you've heard about it, but can you set it aside? That's what this is saying. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. Each juror was, they're citing case law here, where each juror was extensively questioned to determine the degree of their exposure. Where's this footnote? Footnote 4. So they're citing this in this case here. That is interesting because it's not really on point. So the Ninth Circuit found it relevant that the publicity was not unexpected and focused on the facts of the case, not inflammatory materials. So here, again, this is interesting. I don't know why they're citing this as case law to support their argument, because it's really the opposite. What they're saying here is that the Ninth Circuit found that the defendant didn't have prejudice, right, from this pretrial publicity because the publicity was not unexpected and it focused on the facts of the case, not inflammatory materials. Well, here in this case, the leak was unexpected and it was inflammatory materials, right? So, okay. Because of the sensitive nature of the court's voir dire procedures, the state will not address the mechanics of jury selection in its public filing. But suffice it to say, if an individual has been so impacted by the Dateline episode or any other publicity that they cannot be impartial, they will not be seated as a juror. Indeed, this case is not the Ada County judiciary's first experience with a highly publicized trial in recent years. And now they're citing Valid Daybell again. Let's see what footnote 5 says. Oh yeah, the carnival atmosphere. We've seen this in other filings with that citation. Okay, second, the Idaho Supreme Court has rejected the defendant's theory that a continuance is necessary to allow media coverage to dissipate. So this is what we were talking about before, the cooling off period. And Judge said that he thought this, that this was a real thing. That the studies showed this was a real thing that worked. So as the court correctly noted at the pretrial conference, delaying this trial will only allow more opportunities for pretrial publicity. I just don't think that's a valid argument. It's like, well, it's already fucked, so let's let, in an effort to try to unfuck it, it'll just get fucked more. Okay, that's whatever. There's no reason to think that the media coverage in this case will dissipate. So proceeding, okay, well, here's the thing. That may be true, but in my opinion, the biggest issue here is the leaks. They need to stop the leaks because the media coverage is containing leaks. Okay. Defendants' dissipation cases occurred in the 1960s and involved communities where it was presumed or demonstrated that residents had already formed opinions about the case based on local media reports. Here, venue has already been moved and it to the court. Nice. Good typo here. And it to the court will use a much larger pool of potential jurors than in defendant-cited cases. This case is also proceeding in a highly fractured media landscape that bears little resemblance to what prevailed in the 1960s. And there's a footnote here. In this light, it is relevant to consider how the specific jury pool at issue, which consists of citizens from Ada County, may or may not be impacted by media coverage. Local media is likely to continue to consistently report on this case regardless of the trial schedule. Yes, but will it contain leaks? The November anniversary of the murders, for example, generates stories. And then they gave an example. Okay. So it looks like this was maybe written by, whose signature is that? Is that Hurwitz's signature? Do y'all know whose signature that is? Here, venue has already been moved. Oh, we already read this one because there's the footnote. Okay. What happened in defendant-cited cases has no bearing on whether the court can select the sufficient number of impartial jurors in this case. The court should deny defendant's motion because he has not shown that the publicity surrounding this case will prevent a fair trial. And for this reason, for the foregoing reasons, the court should deny the defendant's motion to you. Well, I found this to be lacking. What about you guys? Right, exactly, Twiz. If you delay it, there could be more leaks, so just ignore it. Exactly, right? Sad. It's sad that that's what they're arguing, right? Jesus. You know what's funny, though? If they try to argue that tomorrow before Judge Hippler, I don't think he will take very kindly to that, to be honest. That's just sort of my thought on that one. So it looks like one of the other filings has loaded. I was having issues with these earlier, like I was telling you guys. It looks like I've got one other one that has loaded. I've got all these tabs open, and they're all like, the link is not a real thing, and it's like denied. But there's one that just loaded. Hold on, let me see here. So we can actually go through one more here because it's loaded. All right. So this is from June 4th. This is the order regarding the allocation of reserved media seating. So the court received 2 requests for reserved seating for representatives of, quote, the media, end quote, at trial. Specifically, the court received a letter on May, let me zoom in, 28th from counsel for a media collection asking, among other things, to ensure that someone from the media, why are they always putting that in scare quotes, is always able to be present at trial, that a seat for full media member be reserved. On May 29th, the court received a separate letter from a local AP journalist asking that a full seat for a member of text media be reserved. The asserted rationale for both requests is a concern that the concert-style ticket reservation system will be utilized might result in days when no member of the media is allocated a seat, right? The competing requests highlight part of the problem with reserving seats for representatives of the, quote, media, end quote. Idaho courts do not recognize who or what constitutes media. Oh my God, is this really what we're going to be saying? Indeed. Oh my God. Holy shit. Indeed, in today's world, there are unending people and organizations that can make claim to being media. Are you joking right now? In addition to, I mean, I understand that that could be true, but the state knows full well that with all of these trials, there's like legit media that like has credentials and is like shows up with a badge and it's like, you're legit media. I don't know how that's determined, but it happens in every single fucking trial. Like a random person off the street isn't going to just be able to be like, I'm media. Like that's not going to happen. And this is a really stupid argument. In addition to traditional or mainstream broadcast media, there are newspaper writers, radio news media, independent investigative journalists, true crime podcasters, video bloggers, YouTube streamers, Instagram posters, Facebook page writers and publishers, other social media, quote, influencers, end quote, found on an endless number of internet locations, as well as a plethora of other curators, commenters, and self-publishing journalists. This is really stupid. Trying to obtain a consensus on who should, it won't scroll. Okay, here we go. On who should be eligible for a pooled media representative is impossible. Totally disagree. Dude, this is wild. Come on now. I don't think that the media, when they made these requests, is trying to say that literally anybody who claims to be media would count. I think you have to have credentials. Oh my God. Providing reserved seating for endless representatives of various, quote, media, end quote, types, even assuming those within each such category could agree to whom their representative would be or should be, would result in most of all the limited available seats being spoken for, such that interested members of the general public are unable to attend. Okay. In addition to the problem of defining the media and getting them all to agree on the designated pooled representative, the request for reserved seating presumes a problem that almost certainly will not come to being. Specifically, it seems unlikely that on any given day, every single media member, no matter how defined, fails to wins a seat. Way to go on the proofreading here. Nonetheless, this case does have an unusual twist that does not present in most other cases with a lot of media attention. Specifically, the community most impacted by these murders, the citizens of Idaho County, also the county financially responsible for the cost of the trial, are unable to easily attend because the case was transferred to a venue hundreds of miles away. Given this, and in part addressing the broader concern for media attendance expressed in the letters to the court, one pooled seat for a member of Idaho County local media of wide circulation will be reserved. So that there you have it, guys. One pooled seat for Idaho local media. The local broadcasters, newspaper, and radio journalists located in Idaho and adjacent Nez Perce counties, in parentheses, local media, end quote, must agree to a local representative to attend each day. It need not be the same person each day. Any local media member utilizing the seat must agree, again, we're missing some words here, must agree to act, missing the word to, as a pooled journalist for all media members. The local media must provide a designated list of representatives who will use the seat during the trial to the trial court administrator before the start of the trial. Any person on the list must agree to pool his or her work. The trial court administrator will provide a badge or other document that must be used to gain admission, together with government issued photo identification to prove the person is on the list of local media provided to the TCA. It is so ordered. All right. I can't tell you guys how many documents I've done where I've literally filled this exact thing out, where you put, if there's a blank and you put the number of the day and then you sign it. Although the ones that we have here, you have to write the month as well. So like you'd be like the 10th, you write 10th day of, and then you write like June, and then you do the signing thing. So there you go from Judge Hippler. He doesn't seem to take too kindly to the media. In fact, every single time he uses the word media, it's in scare quotes. So pretty fucking funny. So let me see what you guys are saying in the chat. What's a pile of dung, Kane? Haven't heard the word dung in forever. Never addresses the real. Yeah, he does not like the media. That is for sure. never addresses the real issues. You can tell he's very old school, I will say. I mean, that's clear. He's very old school. It'll be really interesting to see what happens tomorrow. And I wonder if we'll learn more about how it's going with this whole investigation into the leak and, the special prosecutor. Again, a lot of these recent filings, the vast majority of them, like 98% of them, are completely sealed. So I don't think there's anything there. I mean, there could be one of those filings that would provide an update as to that. Although looking at the titles of the pleadings, it didn't even look like that. I'm sure it'll come up because it's completely relevant to the motion to continue. And there's no reason for that to be, kept private. The other thing I will say is that it doesn't surprise me that like so much is sealed now because, Judge Hippler initially was like, yeah, we're not going to be sealing everything left and right. However, when I was scrolling through today, I was like, you know what? In the wake of this whole thing with the leaks, unfortunately, I think this is at least partially due to that. I think it's a consequence, at least partially due to these leaks, because it's like, look, like we're we've seen it before. These could be unsealed at some point, at least while, to our knowledge, they're still looking into the source of the leaks and trying to solve that or whatever. But I understand, although it's frustrating and I hate it, I understand that maybe the number of things being sealed would be, would increase right now. But it'll be interesting to see what happens tomorrow with that. So, but that's all I can read right now. For whatever reason, the Idaho Judicial Cases of Interest page is having a moment, seems like. But we'll see what happens tomorrow with Karen Reed. Depending on if we get a verdict or if there's more jury questions, we'll see what I end up covering tomorrow night. Anyway, we'll just sort of see what all goes on with that. And either way, tomorrow I'll either be covering Karen Reed or we'll be covering this hearing for Bryan Kohberger. And if we cover Karen Reed because there's shit that happens, then we will do we'll do this hearing then one of the other days of the week, Thursday or Friday, something along those lines. So everything will be sealed until trial now. Tongue is totes trending. Kane, crazy head. Right, absolutely. It's being right. Agree. I mean, we know it's being intimated from Judge Hippler that it's either law enforcement or somebody for the prosecution, right? So we know that. But I understand just while I hate it, I understand not wanting to contribute to any further speculation that is now potentially heightened due to this whole mishap, if you will. And I will say that it looks like a lot of these recent filings, maybe not all of them, but probably some of them would have been sealed anyway. Like the stuff dealing with the alternate perpetrators, right? That would have been sealed anyway, Stuff like supplemental expert disclosures, I don't think that would have been sealed, but that is sealed now. An exhibit chart. The exhibit chart, there's an order sealing the defendant's exhibit chart. That would have been sealed anyway. 100% would have been sealed anyway, I would say. We shouldn't, in a case like this, we don't need to know what the exhibits are until trial. Also, happy to see you again, Needs and Z's. So Kane looks like he's going to be streaming the hearing. I will be at the law firm and probably trying to pop in and out of the hearing if I can, as well as Karen Reed, depending on what's happening. So yes. But guys, that'll be it for this one. At least we are caught up on the most important filing, and if not one of the only filings, or well, we had two filings that we can actually read at this juncture prior to the hearing tomorrow. So yeah, so there you go. So yeah, totally agreed. Right. Once it's filed in court, it's no longer speculation. Right. But people will do what they do. You know what I mean? For example, like the exhibit list, right? The defendant's exhibit list or exhibit chart. Again, that's something that I think probably would have been sealed anyway. But if you were to imagine an exhibit chart where it just lists a title of the exhibit with like maybe one or two descriptive words, everybody's going to speculate as to what those exhibits are, right? I mean, it's just going to happen. And it's just going to, I can see how there you want to be careful to not give any more room for discussion, whether it's speculation or not. But like, in other words, if you've got an exhibit chart and there's a word that says potato, I don't know, I'm just making something up, right? You know what I mean? Then everyone will be like, potato, what's the deal with I don't know, you know, just as an example. And then people, as they do with this case, kind of go all over the place with like crazy whatever, you know, and I can understand not wanting to fuel that, as it were. Well, I live stream your live stream. That sounds quite inception-y. I disagree. Now, Twiz is saying nothing to see in Karen Reed until verdict. The jury questions, hello. Everything that happened today was incredibly interesting and really important for so many reasons. I'm sure Need Some Z's will back me up on that. This was a really important day that has like completely and directly affects a lot, not just this case, but potentially other cases, like how Judge Bev is dealing with these verdict slips. I mean, I could go on, but I won't because I did that previously in the other live stream. But this was a big day for Karen Reed. I mean, you're seeing a judge having a direct impact. Anyway, yeah, again, I'm going to not go on about it again. So, jury questions don't matter. What? I'm not even going to address that. That's not the reason that the questions matter. Twiz is saying we think we can see into the jury's minds from the questions, which is kind of true, but in the end, it's meaningless. That is not why those questions matter. That is not why those questions were important today. Absolutely not. The reason it was important is because the jury, yet again, this jury, just like last year, is like, hey, we don't understand what the fuck to do with these verdict slips. And I'm paraphrasing. They had 4 separate issues. They're like, we don't understand this. This makes no sense. And this was the same issue from last year, and the defense tried to fix it, and Judge Bev denied it. And you see what I'm saying? Like, literally, Judge Bev is trying to keep them from being able to come to a verdict. That's the reason it matters, in very short synopsis, if you will. Miss Q just got booted. You know, I said this earlier, YouTube sent out a notification and it went through I don't know if y'all got it, but I got it in my YouTube Studio app, which is for people that are channel creator people, that said that YouTube has a known issue that has been going on, that it's like crashing. So it said they're working on it. So that's probably what that was. Throws red crayon directly into Twiz's beard. Excellent. Love it. So Twiz, did I give you enough of a synopsis to help and explain why those questions were important? Maybe what you should do is watch that stream, because really, 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 really important. Hugely important. I cannot understate the importance of these jury questions today and the significance of how Judge Bev is choosing to handle this. How she handled it last year, how she's choosing to handle it again, and just, it's really crazy. Yeah. Well, we didn't watch for hours. We just literally skipped to the part where they asked the questions. Twiz is saying it's boring and pointless to sit there and watch for hours. Yeah, but we didn't do that because we watched it on Replay Crew. And we literally just skipped around to the part where they asked questions. And we reviewed the verdict forms from this, how they were different from last year to this year with the new chart, with the new lesser included. And we took a look at the defense motion to clarify and amend the verdict slips. And we took a look at the defense's proposed amended verdict slips and how they differ from what the jury actually has. So there was no sitting around for us. Y'all know. Twist said his beard is gone. I don't believe that. I don't believe that. I do not believe that at all. I wish Need Some Z's was still here so she could yell at you, Twiz. Need Some Z's, if you're still here, can you yell at Twiz? Yeah, Twiz's beard will never be gone. That will never happen. That will never happen. Kane, you maybe had too many cough drops or something. I'm just kidding. Can never have too many cough drops, right, guys? She would yell at you as to why the jury questions were so important. Yell at you out of love, though, right? That's what I'm saying. Never too many cough drops. Apparently, Fender bumped into Meg in the Defense Diaries stream, not knowing that Meg was a mod there, which is so fun. I love that. Squirrel friends seeing each other elsewhere and being like, hey, squirrel friends. It was expected. Yeah, it was expected. I mean, it's still just interesting to see it play out. Angel needs a cough drop for sure. Help yourself to a cough drop. Am I accusing you? I mean, I'll let Twiz handle that since it's his beard, man. But anywho, I think Need Some Z's is not here anymore. So Twiz, you're off the hook for now. But anyway, guys, y'all are awesome. I love y'all. We'll be back for more examination of these crazy cases that are going on tomorrow. And it's going to be a big day, that's for sure. Everybody who's going to be watching with Kane, have fun. Again, I will be doing some cool shit at the law firm and trying to listen here and there where I can. And then we will reconvene tomorrow on that. So. Read it again. Read what again? I don't know if that's to me. Is that to somebody else? So yeah, not guilty 100%. Yep. But yeah, anyway, guys, love y'all. And I will see you guys here soon. But for now, squirrel out.